The Health Justice Initiative is heading to court tomorrow. They want government to disclose records concerning the procurement of COVID-19 vaccines. For more on the story, I'm joined by Fatima Hassan, founder and head of the Health Justice Initiative. Fatima, good evening to you. Thanks for your time. So we're at a point where, as a country, we've had to get rid of certain vaccines because of their expiry date. The take-up wasn't great. We're in a post-COVID era. Why does it still matter that these records around procurement of those vaccines are available publicly?
Thanks, Kathy. I think it's precisely because of what you said around the expiry of vaccines, around the late delivery of scarce supplies during a time of great need, because of the huge amounts of public money we've spent on many of these contracts, the details of which are still a secret, even though the pandemic is officially declared over. And I think the main reason why we want to see the contracts with all of the different companies or any other intermediaries that sign contracts so that we could get some supplies during a global pandemic is because in South Africa we do have a constitution and we have a requirement for transparent procurement. So we believe we have a right to know. We believe it's in the public interest to see how at least 20 billion rand of public money was spent and on what terms and with who and why. And we really think that it's unfortunate that our government is now defending the bullying of pharmaceutical companies and is defending the secrecy that they insisted on.
It takes me back to the time around the negotiations under Covid-19, Fatima, of these vaccines. Even then, there was a great reluctance to come out publicly, including basic information like how much a vaccine was going to cost, the issues around who takes liability and that particular insurance scheme, if I can put it that way, over these vaccines. Do you think that the reasons the health department had used at the time are still valid? It sounds to me that they're still arguing the same thing, that, disclosing these details would compromise their relationships with the pharmaceuticals and be in breach of the non-disclosures that they've signed with those third parties.
Thanks. I think that's a great question and it goes to the heart of the case. So, it's one thing to say that government will be prejudiced in future negotiations with these companies. Nobody knows really who the contracting parties are because they're even keeping that a secret. They've said that that is also confidential information. But from the media reports that we have, we know that at least a few contracts were signed or agreements were entered into in government's legal papers. They've gone on oath to confirm which companies they have actually entered into contractual relationships with. But we believe that the defense of the future negotiations being placed at risk and the breach of the contracts is not sufficient to pass constitutional muster in South Africa. In an emergency, you can't have that much of secrecy, even outside an emergency, even under national health insurance. We believe that the NDAs are an unconstitutional method to demand secrecy basically from the multinational pharmaceutical sector. And you must remember this comes off a report that Transparency International has also just released to show that globally, less than 10% of the vaccine contracts around the world are actually open. So you have a situation of an unprecedented global pandemic during COVID, and with it you have unprecedented levels of secrecy. So we believe that government should have in its legal papers explained how in actual reality, they were going to be prejudiced in negotiations. They haven't set out the case for that. And also, which particular terms and conditions can't be made public. It's really, a dangerous level of secrecy and non-disclosure to have if you say that every single term and condition, including who signed the contracts, including the contracting parties, are secret. That's certainly not a sustainable way for procurement in the health sector going forward and in the next pandemic.
Fatima, earlier you described Big Pharma as being the bully here, at least in this conversation against government. Why not go to the bully itself as the Health Justice Initiative to put pressure there too and ask them to also make these records public?
And that's precisely what this case is doing. We've said that the onus is on government. If it's refusing for the last 2 years to tell us who it actually signed contracts with, we are at a disadvantage as the public. We can't include those parties. We can't serve legal papers on entities that are unknown to us. And so the onus is on government to have actually joined those parties and to inform those parties that we are asking for disclosure of the contract. So at the heart of the case is really the role that our government played, as well as the role of these companies, as well as other intermediaries and initiatives. But, we'll have to argue this case tomorrow, and we'll see how the court responds in relation to which parties should be before the court. But we have certainly argued, and we believe that at this stage, only the Department of Health knows which parties they contracted with, and they have the details, and they are refusing to make that information even public.
Now, Fatima, being heard tomorrow, but certainly it's one of those cases that I see ending up in all likelihood in the Constitutional Court simply because of the kind of precedents that it's likely to set. We'll leave it there for today. Fatima Hassan, founder and head of the Health Justice Initiative.